right, let's go through the rest of these. Okay. A comparative market analysis, A, is the same as an appraisal. B, can help the seller price the property. C, by law must be completed for each listing taken. Or D, should not be retained in the property's listing file. B, can help the seller price the property. A written agreement.
I'm sorry, could you repeat the question for that?
Yep, a comparative market analysis.
Okay.
A written agreement between a broker and a client includes the following language. In return for compensation agreed upon, the broker will assist the client in locating and purchasing a suitable property. The broker will receive the agreed compensation regardless of whether the broker, client, or some other party locate the property ultimately purchased by the client. What kind of agreement is this? An exclusive agency listing, an exclusive agency buyer agency agreement, an exclusive buyer agency agreement, or an open buyer agency agreement? C. Exclusive buyer agency agreement.
Exclusive buyer,
Agency agreement.
and that's an writing agreement between who? At the beginning?
The buyer agency is the broker and the buyer.
Oh, the broker and the buyer.
Mhm. In Pennsylvania, what is the first document that must be discussed with a potential seller of a home built in 1921? A, comparative market analysis. B, lead-based paint hazard disclosure statement. C, consumer notice. Or D, seller property disclosure statement. Consumer notice, letter C. To what property does the Real Estate Sellers Disclosure Act apply? A 50-unit apartment building. B, agricultural property of less than 10 acres. C, a 3-unit apartment building. Or D, an old manufacturing facility. C, a 3-unit apartment building, because it's 1 to 4 family residential.
What was the question again?
To what property does the Real Estate Sellers Disclosure Act apply?
3-unit apartment building, is the answer?
Yes,
Okay.
3-unit apartment building.
Thank you.
Uh-huh. All of the following provisions are usually found in the listing agreement except A, the broker's compensation, B, monthly utility bills, C, the list price, D, the contract expiration date. B, the monthly utility bills. The sellers hired a broker under the terms of an exclusive right to sell listing. While the listing was in effect, the sellers, without informing the broker, sold the property to their neighbor. How much, if anything, must the sellers pay the broker? Nothing, the broker's marketing expenses, full commission, or half commission? Full commission, letter C. Because it's an exclusive right to sell. In a fiduciary relationship, the agent is primarily responsible to whom? The customer, the client, the lender, or the lending broker? The client.
What was the question one more time?
In a fiduciary relationship, the agent is primarily responsible to whom? Be the client. Which is a similarity between an open listing and an exclusive agency listing? A, under both, the sellers avoid paying commission if they find the buyer. B, under both, the sellers are guaranteed to net a certain amount. C, under both, broker earns a commission regardless of who sells the property as long as it's within the contract dates. Or D, both grant an exclusive right to sell to whichever broker procures a buyer for the property. A. I'm gonna repeat the whole thing.
Mhm.
Which is a similarity between an open listing and an exclusive agency listing? And it is under both, the sellers avoid paying commission if they find the buyer. Everybody good? A real estate purchaser is said to have equitable title when A, the sales contract is signed by both the buyer and seller, B, the transaction is closed, C, escrow is open, or D, a contract for deed is paid off. A, the sales contract is signed by both the buyer and the seller. When a buyer promises to purchase a seller's property only if he can sell his present home, the buyer's protection from owning two homes at once is called what? An escrow, an option, an equitable title, or a contingency?
Contingency.
D, contingency.
Can you repeat that question?
Yep. When a buyer promises to purchase a seller's property only if he can sell his present home, the buyer's protection from owning two homes at once is called D, a contingency.
Thank you.
A listing taken by a real estate salesperson belongs to whom?
Broke.
Thank you. I wasn't gonna give you those answers. The relationship of a broker to the client is that of a trustee, a subagent, a fiduciary, or an attorney in fact. Fiduciary, letter C. Which of the following is a similarity between an exclusive agency listing and an exclusive right to sell listing? A, under both types, the seller retains the right to sell the real estate without the broker's help, without paying the commission. B, under both, the seller authorizes only one particular salesperson to show the property. C, both are given the responsibility of representing the seller to one broker only. Or D, both are open listings.
What is the similarity
C.
between exclusive listing and
Exclusive agency listing and an exclusive right to sell listing.
You said C.
C, both are given the responsibility of representing the seller to one broker only. A house is rumored to be haunted. Additionally, the central air is not working properly. Under Pennsylvania law, what must be disclosed? The rumored haunting, the broken central air, both, or neither?
B?
The central air, yep. What are,
Maybe the ghost is actually coming from the.
I mean, maybe. Maybe that's why it's not working.
Honestly, I mean, if you know,
Never know. Water leaks into the basement only in the spring when the snow melts. The basement is dry during the summer. This is an example of what? A, a latent defect that does not need to be disclosed. B, a latent defect that needs to be disclosed. C, a problem that must be dealt with only when it arises on the market. Or D, an example of caveat emptor.
B.
B, a latent defect that needs to be disclosed. After a buyer makes an offer to purchase, the broker cannot locate the seller to present the offer. In the meantime, the broker receives another offer for a higher price from another buyer. How should the broker proceed? A, decide which offer is best to present to the seller. B, present the higher price offer. C, inform the first buyer that the broker cannot present his offer because it's too low. Or D, present both offers at the same time.
D.
Yep, present both offers at the same time. In Pennsylvania, at what time should an estimated statement of closing costs be provided to the buyer and seller? A, prior to settlement. B, after acceptance of an offer. C, within 24 hours of communication of an acceptance of an offer. Or D, prior to signature of the agreement of sale.
D.
D, prior to signature of the agreement of sale. Before they actually sign the agreement of sale an agreement to purchase, they should have their closing costs. You're generally going to present them at the same time that you're doing it. In all rights, you should have them sign the estimated closing cost before they sign the agreement so that they know what to expect.
So the question was, when does the buyer get the closing cost information?
At what time should an estimated closing cost be provided to buyer and seller? Yes, and it's prior to signature of the agreement of sale. The purchaser of real estate under an installment contract, A, generally pays no interest charge. B, requires legal title immediately, or receives legal title immediately. C, is not required to pay property tax for the duration of the contract. Or D, acquires equitable title. The purchaser of a real estate under an installment contract. A, generally pays no interest charge. B, receives legal title immediately. C, is not required to pay property tax for the duration of the contract. Or D, acquires equitable title. And yes?
D.
D, acquires equitable title. Yep, if they're doing a lease purchase, they have equitable title. A minority real estate broker's practice of offering a special discount to minority clients is satisfactory, illegal, legal but ill-advised, or not important.
Illegal.
Illegal. Generally, if you use common sense, you're pretty good. In their offer to purchase a home, the buyer stated, if we cannot obtain a mortgage loan for under 5.5% or less, we will not purchase the property and we expect to receive our earnest money to be refunded. This clause is an example of what? An addendum, an amendment, a reversionary right, or a contingency?
Contingency.
Contingency, letter D.
What was the example you gave?
The buyer stated, if we cannot obtain a mortgage loan for under 5.5% or less, we will not purchase the property and expect to receive our earnest money deposit to be refunded. The listed price for the property should be based on what? A, the net to the seller. B, its appraised value. C, what the seller chooses. Or D, the maximum of the range of values.
C.
Yes, C, what the seller chooses. A lot of times it is D, but it's actually C. They try, they want the highest part of the range. 6 weeks after the couple listed their property with a broker, the broker brought a full price offer and with cash who were ready, willing, and able to purchase. The couple rejected the buyer's offer. In this situation, the couple, A, must sell the property because they received a full price offer. B, owe a commission to the broker. C, is liable to the buyer for specific performance. Or D, is liable to the buyer for compensatory damages.
C.
Nope.
The broker.
Yes, owe a commission to the broker. They don't have to sell it, but they do owe the commission.
Did you study?
Who are the parties to a listing contract?
Mhm.
I'm sorry.
Who are the parties to a listing contract?
Principal and agent?
No.
The listing broker and the seller?
Yes, broker and seller.
You studied.
I got it wrong.
An offer to purchase binds whom? The buyer, the seller, neither the buyer nor the seller, or both the buyer and the seller. An offer to purchase. Yes, the buyer only. because the seller doesn't have to accept it. But if the seller accepts it, the buyer
The
has to.
question is the offer,
An offer to purchase binds whom? A buyer offers in writing to purchase the house for $220,000, including its draperies, with the offer to expire on Saturday at noon. The sellers reply in writing on Thursday, accepting the $220,000 offer, but excluding the draperies. On Friday, the buyer considers the counteroffer. The sellers decide to accept the original offer, draperies included, and state that in writing. At this point, the buyer, A, must buy the house and has the right to insist on the draperies. B, is not bound to buy. C, must buy the house but is not entitled to the draperies. Or D, must buy the house and can deduct the value of the draperies from the $220,000.
B,
B, is not bound to buy.
because they changed it, right?
Right.
As soon as they change
As
it,
soon as they change it, that offer's completely gone.
Those are ugly draperies anyway.
Probably. An agreement of sale in Pennsylvania must contain all of the following except A, a disclosure of whom the broker represents. B, a disclosure that the rate of commission has been negotiated. C, a statement about the recovery fund. D, a statement about zoning classification, except for a house on a lot zoned for single-family dwellings. An agreement of sale in Pennsylvania must contain all of the following except A, is disclosure of whom the broker represents. B, is disclosure that the rate of commission has been negotiated. C, a statement about the recovery fund. Or D, a statement about the zoning classification except for a house on a lot zoned for a single-family dwelling.
Recovery fund.
B, disclosures that the rate of commission has been negotiated. Because that is not in an agreement of sale, that is in a listing agreement.
I'm sorry, can you repeat the answer?
Yep, disclosure that the rate of commission has been negotiated. Everybody good?
Yep.
A licensee tells a prospective buyer, this property has the most beautiful river view. In fact, the view includes a river and the back of a shopping center. The licensee, A, has committed fraud, B, is guilty of negligent misrepresentation, C, is guilty of intentional misrepresentation, or D, is merely puffing.
see?
Puffing, letter D, is merely puffing. And that, folks, concludes our 30